Hey everybody, Derek Christensen here. I'm an estate planning attorney who owns Legion Law, a premier estate planning and probate firm in Dallas, Texas. Today I wanted to tell you about how you can edit your documents without having to renew them every single time your estate plan changes. And they will change over time. But before I dive into that, feel free to reach out to me. You can email me directly, Derek, D-E-R-E-K, at legionlawpllc.com, or you can find me on my website, www.legionlawpllc.com. So with that, let's dive right in. Now, this is a common concern because people pay good money for an estate plan, and then they are worried that if something changes, they got to pay all of that all over again. But they don't. And there are ways to edit these documents that don't require paying for the entire thing all over again. However, each document is done differently, and sometimes the requirements can vary from document to document. And if you don't do a correct edit, then the edit doesn't count and you're back to square one. So, how do you edit these documents? For a will in Texas, there's a specific thing called a codicil, which is where you create a document that is essentially an amendment to the will. You say, this is my will, I made it this time, on this day, I made these directives here, I'm actually changing this language to here. And you'll want to specify a lot of different identifying information. You'll want to specify again, if it's your will versus your spouse's, if it's, what changes you're making, the day that you signed it, the witnesses that were on the document. You want to make it so it's very verifiable. We know exactly what you're talking about, which document you're talking about. And you'll want to specify, I'm changing this language or I'm adding this language at this specific spot. And you'll be able to say, all right, we have the original will and we're going to include this language here, or cut and paste or whatever. So you'll want to make it extremely clear. And you'll also want to make sure that the amendment doesn't conflict with anything else inside the will, because if it does, boy, things are going to get really confusing really quick, and that's just inviting a lawsuit. So, additionally, and when it comes to this codicil, you're going to want to make sure that you execute it the exact same way that you did a will. So you're going to have to sign it, you have to get it witnessed, and you'll want to do a self-approving affidavit for the codicil, which means that you're going to have 2 witnesses and notary, and it's just like a lot of signatures just to make that a little amendment. And it's the same requirements for the witness requirements as well. So they have to be above 14 years old. They have to understand who you are. They have to, and that they know that you have testamentary capacity. All those requirements are still the same for amending a will. Now, amending a trust is very similar, and amending all these other documents are actually very similar to one another. But essentially, you're going to repeat the same process. You're going to have a document that says First Amendment to the Derek Christensen Trust, dated whatever date I signed it. And you'll say, all right, I am identifying the trust. This is what it said. This is what I'm changing that language to. And then I'm going to sign it and notarize it, et cetera, et cetera. So again, you'll want to make sure it doesn't conflict. And that is a very, very important point to make sure that you're doing correctly, because any confusion, like I said, invites a lawsuit. So when it comes to your other documents, however, like a financial power of attorney, medical power of attorney, advanced healthcare directive, HIPAA release form, you've already signed them, you've already got them notarized or witnessed, and they should be good to go. You don't need to redo them. And oftentimes, you can actually just handwrite exactly what you want to change on there. In my documents, I leave large spaces where I say, follow the medical power of attorney must follow this directive, and there's a blank. So you can handwrite and say, all right, 3 years later, I realized I don't want to be subject to anesthesia. Never anesthesia. Don't ever do anesthesia. So I can handwrite in and say, don't ever do anesthesia. I'll initial it, and then I'll date my initials. You don't need to have like a formal document that says the First Amendment to the financial power of attorney or whatever. You technically can, but it's very easy to just handwrite stuff in and initial it and make sure you scan it in and replace any electronic copies you have of that document as well. So that's kind of the way that you can approach it with advanced healthcare directives. In other words, do not resuscitate forms. Medical, financial powers of attorney. You can do those amendments that way with those documents. Now again, there's the formal way to do it. That's the informal. You can do both when it comes to those documents. When it comes to your trust, I would strongly recommend do not handwrite anything in. that, again, it becomes kind of confusing and difficult to understand. So if you have a formal document outlining very clearly what's happening, that is the better way to approach that. You technically could do the informal approach, but I strongly disagree and don't recommend it whatsoever. The will, again, is probably the most difficult to amend, but it is still possible. And again, you don't need to get a brand new will every single time. So working with an attorney, you should contact the one that drafted your estate plan in the first place. If they don't let you make amendments, that sounds pretty dang strange to me. But if they do not do that, then you can do it yourself in certain ways. So contact the one that who drafted it. If they do, great, take them up on it. If they don't, try to do it your own, but that still makes me a little nervous, and you might have to go to another attorney to redo your estate plan. So push comes to shove, it's not the end of the world. The estate plans are not set in stone. You don't have to follow them all the time, and obviously things are going to change over time. Children might pass away, executors might move away, and you're not friends with them anymore, whatever. So as those changes happen and major life events happen, be sure to review your estate plan. So thank you so much, and have a great day. Be sure to reach out to me if you have any questions. You can find me in my email, Derek, D-E-R-E-K, at legionlawpllc.com, or you can go to my website and schedule a free consultation over the phone directly onto my calendar at the Contact Us page at www.legionlawpllc.com. So thanks so much for watching.